Baron, looking forward to this panel. It's our in-house counsel keynote discussion. And let me start by introducing our moderator, Jim Lundy. Jim is a partner at Foley and Lardner, located in Chicago, where he's a member of the firm's Securities Enforcement and Litigation Practice Group. Jim previously served as Senior Regulatory Counsel in the SEC Examination Division and Senior Trial Counsel and Branch Chief in the Enforcement Division. He's also our program chair for this afternoon, so you'll be hearing more from Jim this afternoon. Welcome, Jim. Thank you.
Thanks, Bruce.
Next to Jim is Carrie Chelko. Carrie's Executive Vice President and General Counsel at Jackson Financial. At Jackson, she oversees the firm's legal, compliance, government relations, corporate responsibility, and corporate communications teams. Welcome, Carrie. Thank you. Next to Carrie is David Glockner. He's Executive Vice President for Compliance, Audit, and Risk at Exelon Corporation. And David previously served as Regional Director of the SEC Chicago office and as the Chief Compliance Officer at Citadel. David, good to see you. Next down is Jason Howard, Chief Legal and Regulatory Officer at Dialectica. He was formerly General Counsel and Chief Compliance Officer at, is it Tegas?
Yep.
Tegas, and also previously served for over 13 years in the SEC's Division of Enforcement. Thank you, Jason. And finally, at the end, we have Shamoil Shipchandler, Chief Counsel for the Risk and Regulatory Group at Charles Schwab. Before joining Schwab, Shamoil was a partner in Jones Day, but he also previously served as Director of the SEC's Fort Worth Regional Office and as a Deputy Criminal Chief of the U.S. Attorney's Office in the Eastern District of Texas. Shamoil, welcome, and thank you, and let me turn it over to you, Jim.
That's great. Thanks so much, Bruce. Thanks to you all for hearing us out during your lunch. Hopefully they save some out there for us when we wrap up. Some of what we're going to cover, the topics overlap with what's been talked about earlier and may overlap a little bit with what's going to be covered later. But our panelists here are going to be offering their perspectives from the in-house chairs that they're in, and also their perspectives in their prior areas, including having both Shamoil and Dave as former regional directors. And with that, we're going to start with Dave and Shamoil regarding how, in their roles now in-house, but also drawing on their prior experiences in the regional director chairs, how are they seeing the change in leadership at the SEC impacting their organizations?
So I would think for my organization, the impact is close to zero. I mean, it's the laws and regulations are still the laws and regulations, kind of regardless of how they're enforced. Most companies, I think, like ours, we play a long game. The statutes of limitation often outlast administrations. Bad habits certainly outlast administrations. And so we're certainly following what's going on in the enforcement space, but we're not changing behavior as a result of it. I think the one thing that from my perspective, and I don't want to use the word pause, but lighter period of enforcement offers in-house teams the opportunity to do, and I think we have deliberately tried to focus on this some, is use the period of time when you're not consumed with enforcement issues to get your house in order and to do some of the long-term harder issues that are maybe a little trickier to do when you've got teams running from subpoena to subpoena or inquiry to inquiry. And it's actually a valuable period, and take advantage of it.
If you guys will go simply by the pictures on the screen, you'll notice that Dave is desperately trying to escape his box, and I'm desperately trying to be heard, which is a lot like how we had things at the commission. But what I would say is, I look at this, the leadership and the focus on fraudulent activity, of course, gives you an opportunity then to avoid some of the more technical violations that we saw in previous administrations. And so I think that's been sort of made clear from speeches. But I often think about this in terms of resources. I tend to think that the SEC, because of how leadership is allocating its resources and the limitation on resources, is going to have to make some difficult decisions. And those difficult decisions are going to be where and on what kind of conduct that it focuses on, which will change the balance and the mixture of the kinds of companies they investigate and the kind of conduct that they investigate too.
Yeah, thank you both. Carrie, turning to you, you're a general counsel of a large public company. that has affiliates that are SEC registrants. So how have you seen, if at all, your company impacted from your role as the general counsel?
I would echo the comment that, zero if at all. I mean, we play the long game as well. We're focused on doing what's right, having a strong compliance program. And so I think, there could be a shift. I mean, we offer products that ultimately make their way to retail customers. If there's fraud someplace in the intermediaries, activities, I think the focus on the SEC sort of getting back to the basics and focus on, individual frauds, could that play out in our sector, in the insurance sector? It could, but we don't see a big shift, and we'll continue to operate, I think, the way we've been operating. I think it feels like there's a good shift in that there's a focus on getting back to, real investor protection issues, stepping away from sort of the innovative and creative legal arguments that end up being these, aha moments or trying to regulate by enforcement. So I think it feels like we're heading in the right direction to at least get back to the basics.
That's great. Thanks, Carrie. And Jason, you come at this, your firm is really international, but your client base are U.S. registrants for the services you provide. What are you seeing from your role at Dialectica, and what are you hearing from your clients?
Yeah, I think, obviously, I think most legal and compliance professionals share the same view of like, hey, keep the status quo, maintain strong controls and robust compliance, yada, yada, yada. What I would say from my position, like Dialectica is a primary research vendor, and so I am sitting and watching the interaction at registrants between their compliance teams and their business and investment teams. And I think I've shared this with the group earlier, but this is just anecdotally, but I do feel like I am seeing more, I don't want to say tension, but some more pushing the boundaries by the business side when it comes to research. What's acceptable, what's not. Does this compliance rule really apply to this? Can we talk to this person, not talk to that person? So I think maybe that's one knockdown effect you're seeing from this, at least the perception of the administration, is that maybe the investment teams or the research teams are being a little bit more aggressive on what they're digging into, and the compliance rules aren't loosening up. We're seeing compliance hold strong, but I think anytime you see the business pushing the compliance team, it's a little bit disconcerting. I think in the previous administration, you saw people just being, the business and compliance teams being totally in lockstep. I would say the caveat there is like this observation is more so from the smaller and mid-sized firms. I think the big top-tier firms are still very much listening very loud and clear to their compliance teams. But in those smaller firms, we have smaller people, and the portfolio manager has an outsized presence and voice. I think that's where you need to be a little bit more cautious.
That's great. Thank you all. Why don't we turn specifically to enforcement? Just a couple of weeks ago, Judge Ryan was announced as the new enforcement director. And again, I'll just start with Dave and Shamoil. You guys obviously in your current roles, but also based on your former roles and in the close relationships you would have had with the directors you served under, what do you foresee in terms of what the future may hold under Judge Ryan in that director's chair under Chair Atkins as we look forward to the SEC Enforcement Division and what its priorities may be?
So I think the point that Shamoil made a couple minutes ago about the focus being less on technical violations and more on kind of substantive investor harm issues is a pretty easy prediction. This is a time of tremendous change at the commission. A lot of senior staff turnover, significant amount of their particularly complex and fraud-related work is done in partnership with the Justice Department. That's also an organization that's going through a lot of changes. I would expect to see fewer really complicated, challenging cases coming out of the SEC. It's just going to be harder for them to do them because of the reduction in resources, the turnover in staff, a loss of a lot of senior people, and the diminishment of resources in some of the partner agencies. I think the bread and butter Ponzi scheme, investor fraud, offering fraud cases need to be brought. They will continue to be brought. But at least personally, I don't expect a tremendous amount of sort of sophisticated, complex work coming out of the commission in the next couple of years.
Shamoil, what are your thoughts? And also your perspectives now at Schwab, which obviously is a significant, very large registrant overseen by the SEC.
Yeah, I agree with what David was saying, and and what I would say is, in some ways, I think about this as the adjudication before the adjudication. When you have the enforcement director who's applying an adjudicatory lens at a recommendation that's being made, you're going to have a little bit of a different of an evaluation. If you have a former prosecutor in the role, it all really comes down to your mentality and how you see the world. If you have a prosecutor in a role like that, a prosecutor is often looking as to how to make the case. Are the elements of the case there, and how do I present that case, and does this constitute a violation, and if so, how do we get it into court? If you're looking at it through an adjudicatory lens, then you might apply more of a calculation of what do the witnesses look like, and what does the public think of this kind of conduct, and does this constitute something that the SEC really wants to be known for? And so some of the arguments that defense lawyers would typically make, that the strength of the witnesses, the weakness of the conduct, the idea of this is different than a priority that the commission would have, all of those things I think get more resonance when you're looking at it with the judicial perspective as opposed to being a prosecutorial mindset. So I think you see a shift there where the kinds of conduct that you're after are more of your bright line kind of conduct that most people would agree would constitute a crime. I used to joke when I was a justice that if you gave me a jury full of 12 drug dealers, I would still convict the Ponzi scheme person. And I think that's largely the case. We would agree on the bright lines of what fraud entail, but I think we have a wide variety of opinions on more technical violations, and I don't think you'd see those kinds of things happen.
Yeah. And Jason, how, with your client base, kind of that smaller to mid-sized firm, what are you hearing? Also, in your role at Dialectica, what do you anticipate from enforcement under Judge Ryan?
I think the only thing I would remark, not necessarily my current role now, but more so just my previous role, I think, in seeing changes in administration and then this more extreme change in administration. I think you've heard a lot of I think you hear a lot from the commission that, like, hey, it's status quo, we're still going to investigate and prosecute securities violations and things like that. But I think the reality is that there are finite resources at the commission, number one. And number two is, like, you can say that all you want, but when the administration has a particular point of view or they want to do sweeps on certain areas, that's where your resources are going to be directed. And so I think, I think it's not necessarily status quo. Maybe that does open up that view towards, all right, they're not keeping their eye on everything today, especially when you hear about even more potential reductions, as we were talking about, as one of the panelists was talking about earlier today. It kind of opens up that, like, there's just not as many cops on the beat. And does that introduce some, like, ill-advised behavior on the business side of things to watch out for?
How about Carrie, in your role, again, that public company perspective coupled with multiple registrant affiliates, what are you hearing from your people? I know you oversee, like, Josh, for example, this is his purview in terms of litigation and managing, any potential regulatory risks. What are you seeing?
I'll hit it more from the angle of practitioners that I've talked to, and I've been at companies that are, other companies as well that have gone through enforcement in the past, but I think one of the biggest observations we have, I think I read a statistic that it was 45 or 46% fewer cases in the first 6 months of this year. Could be that they were pulled through, there was more filed in the last 6 months of the prior administration, but 46% fewer cases, 15% less staff. Just as a leader in a company, if you're losing 15% of your staff, the capacity to be able to do the amount of work it's a challenge. And so I think our expectation in talking to team members and to practitioners is that they're gonna have to narrow the focus to go back to the basic bread and butter cases and the less complex ones, because they do not have the staff or the expertise to be able to handle the more complex, innovative. So at least the messaging seems consistent with what you would assume just by looking at the numbers.
Yeah. Thank you all. And, you know, in
Jim, we
partic-
can't let you off that easy. I mean, we're all clients. What are you advising us? What should we expect?
Wasn't expecting that.
That's not in the script.
This is free, by the way. So this is how you do it in-house. We get that free advice right now, and I'll diligently take notes, and I'll report it up the chain.
Military background and a judicial background. I think there's going to be a law and order approach. And I think your point was a great one, which was, you know, in the recent decade, actually going back to Director Kuzami, people with some sort of prosecutor background had been in that director's chair for a while. I think prior to Gensler, we saw a more aggressive enforcement staff, including under Jay Clayton. Like, if people think it was really touchy-feely under Trump 1, ask some of the investment advisors whose firms had to go through the 12B1 self-reporting process and all the revenue sharing investigations, which was really kind of the start of regulation by enforcement. It didn't start with Gensler, it started with Chair Clayton, with all due respect to him. So I think it's going to be law and order. I also think, and I'll welcome your thoughts on this, I think we're going to see more engagement in the pre-Wells process and in the Wells process. I know what some folks said on the staff and some of the other panelists, that, you know, you were still welcome and that was still being entertained. The reality is the message that was being sent out of the prior regime was very chilly in that regard. And not just at the pre-Wells stage, but also at the Wells stage. And I think that's going to change, and I think it's going to be welcomed by Judge Ryan. Do I think Judge Ryan has the capacity or interest to sit in all the Wells meetings? Of course not. But I think the message from her on down to the staff level is going to be, we want to provide a forum where counsel, outside counsel coupled with their clients, can come in and be heard specifically in the Wells process and in appropriate cases earlier on. And that being heard also means we may have a greater opportunity to steer the investigations in a way that could result in favorable outcomes for our clients.
Once we figure out the chain of command.
Yeah, that's true.
Because right now, it's a little hard to figure out who's doing what.
Yeah, that's very true.
I'll hit on the Wells process and some of the changes that I expect. I know, you know, at prior companies, the analysis we went through when there was a Wells notice was, is there even a point to respond to it? What's the point of you know, you're budgeting out what the case is going to cost. Why put all the effort and energy into responding to the Wells when it's a futile effort? I think that analysis is going to be a lot different now with in-house people that think there's actually, you know, I think the statistics will play out as to how often maybe you can avoid the charges, but at least it seems like it won't be a futile process. The analysis may be, let's take the time and do the advocacy now. If the current staff is as transparent as I think we're seeing the news articles say they will be in there, sharing the information that they have to support their charges, I think that will be a really helpful part of the process. Good improvement.
Yeah, those are great points, Carrie. I think we'll all agree.
Well, and beyond just the setting out the facts, I think there's an opportunity also to frame the arguments in ways that are sort of shaped to or tailored to some of the policy agenda items of this administration, which was not so easy to do in the prior administration, where I think there was a perception that the policy agenda of the administration at the time was to bring the case against you, and that made conversation about, well, is this a good case or a bad case, a little challenging.
Yeah, and I'll just jump in with another thought. Even prior to the Wells stage, Shamoil and I were talking earlier, someone earlier said it really does depend who the people are on the other side. That's always been the case. I'm sure there's some defense counsel I was across from that didn't think I was particularly friendly at times in my 12 years on the staff. But I have noticed more transparency. You know, we were down at Fort Worth presenting to some of Shamoil's former colleagues, and they asked to talk to us afterwards. This was back in February when everything was brand new. And they said very frankly that under this regime, they don't know if this is a type of case that they'll have commission support for, but they would get back to us. And they actually got back to us over the summer and said, listen, this isn't a Wells and we're still investigating, but we're going to move forward. We think that this commission under Chair Atkins would be supportive of the theories we're exploring. And, my client was disappointed to hear that, but we appreciated the transparency. I mean, it was very much like, we're going to move forward and, we're going to send a request and we'll proceed. And so part of it was these were just really, really good, transparent staff, but I don't think they would have been that proactive under a prior regime.
Yeah.
Well, why don't we switch gears a little bit? I know some other panels touched on this in terms of, DOJ, states, et cetera. But why don't we start with the DOJ? Dave, you had mentioned for more serious cases, obviously parallel actions and a close working relationship. But the U.S. Attorney's Office, you're a proud alum of the Northern District here, and DOJ in general, they've been faced with significant challenges with resources and changing priorities. But how, if at all, do you see from your role now in-house, what, if anything, there may be going forward with criminal securities fraud types of activities?
Well, I think everything that we said about the challenges the SEC faces and the need to prioritize within the SEC applies even more so to DOJ. They are pulled in more directions. I think that's an agency that is in kind of a greater level of turmoil than the SEC. So I think there may be a handful of criminal securities fraud cases, but I would expect them to be really bad, obvious conduct, blatant fraud, not sort of push the envelope stuff.
And Shamoil, turning to you, Schwab is obviously, in a multitude of business lines in every state. How do you see the states maybe attempting to fill any sort of perceived void by the SEC over the next several years?
Yeah, one follow-up point on David's comments on DOJ. This is a free tip. If you're going to commit securities fraud, don't let it touch a drug cartel. Just keep those two things separate and you might have a chance. So I would say, we've talked a lot about how the commission is more focused now on sort of those fraudulent activities. You might have the ability to have a conversation with the commission, and these are all things that are reflexive for us. We understand generally how to have a conversation with the staff and how to appeal if we need to appeal, and we can speak that same language. What I would say is that in instances like this where the federal government recedes in some of its core enforcement areas that we've seen before, the state sometimes will rush to fill the gaps. There was a statement made previously by NASA that they were looking to essentially find instances of conduct that they could turn into sweeps. And so they're aggressively pursuing the idea of if we can find areas that the SEC is not going to touch, we can turn those into nationwide sweeps. And so it's kind of the idea of be careful what you wish for, because while we understand very well how to interact with the SEC, even though we might not like the answers, the states are a very different kind of a mechanism of enforcement. They've got a different kind of home field advantage. They've got different political considerations associated with them. Sometimes they're very quick to publicity. And so all of those things create a portfolio of risks that we haven't necessarily seen in a while.
And Jason, with, I think the state regulatory enforcement environment can be, I think, potentially more material to smaller size firms that your firm works with. What are you hearing from your client base regarding state activity?
Not much. I don't think it touches our business all that much. I think from our business perspective, though, when it comes to engaging in the United States, it does make us think about where we want to have a presence. I mean, that's really the major impact on it.
So in terms of presence, that'll be a good segue, Carrie, to talk to you. We talked a little bit to build on what Shamoil was saying. You typically, not to be political, but you see the blue states tend to ramp up. But there's also been some developments in some of the red states as well, such as, Texas is clearly looking to be a challenger to Delaware for state of incorporation, and that impacts shareholder lawsuits. What are your views on that area?
Yeah, with the first administration, or the first Trump administration, I think Shamoil's point of, NASA, the states were ramping up and covering their perceived gaps. I think that's the sort of the key word. With this administration, it feels like, some of the red states are actually not necessarily covering the gaps, but trying to amplify some of the policies of this administration. So Texas, for example, recently passed legislation that would regulate proxy advisors like the ISSs, the Glass Lewis's, to the extent that they're providing advice, voting advice, proxy advice on non-financial terms like ESG. And so there's a challenge to that legislation right now, but I found it interesting that, we might see in the second administration, states not necessarily filling the gaps, but amplifying some of the current administration's policies.
Yeah, that's a great point. What about private litigation? I think we were talking in the green room, there's been some data that it is increasing. I know, Dave, one of the points you raised was that, kind of let's see what the future holds, that it may not necessarily just be a quid pro quo, that enforcement goes down and the plaintiff's bar increases in this space. So what are your thoughts on that?
I think my observation there is that historically there's a fair amount of plaintiffs' litigation that is built on work that's done by the SEC and DOJ. And so if you see that sort of waterline decrease, there are going to be at least potentially fewer private actions. And that's total speculation on my part, but I think that's one possible outcome here.
I tend to trust David's speculation. That's the problem. No, I agree. It's hard to tell what that the civil litigation portfolio will look like. There are oftentimes the follow-on actions for the regulatory pieces that you see, but I don't know. I don't know what that's going to look like. We're mindful of it. It's always a risk that exists out there. What I would say that's kind of unique and new about this administration, though, is that in areas, in highly sensitive areas like DEI and ESG, for example, are two that I'm thinking of with executive orders on them, there's now an incentive structure for private litigants to file cases, essentially on behalf of the federal government in order to enforce the federal government's rights. And so what it does is it takes some of these core areas out of the hands of regulators and puts them in the hands of private litigants who are incentivized very differently. So I haven't seen that kind of thing yet, but that's an interesting twist on some of the executive orders that came out earlier.
And Carrie, you're our other public company GC up here. Obviously, you oversee teams that have different expertise in different areas. How do you see kind of the potential increased risk of increasing private securities litigation? And how are you thinking about that in terms of, the people you supervise, talking to senior management, talking to your board?
Yeah, I mean, I'm going to defer and maybe rely on what Dave said as,
Yeah.
I trust his gut as well.
Dave, you need to set up a side consulting business regarding your views on private securities litigation.
Optimistic thinking.
So let's talk a little bit about off-platform messaging and text messaging. Right, there's going to be no enforcement activity in this space in terms of cases being brought. But it's worth discussing, I think, for a couple of reasons. I'll start with my own view. I don't work in-house, but I have a client that received a subpoena in an insider trading case, and 5 of the requests are every which way to Sunday talking about messages. So enforcement is still going to have an expectation, in particular for an area like insider trading, which I think most agree is going to be a priority under Atkins. And as others have said, they are still doing their work. And I think we're going to see an expectation of messaging being produced to the enforcement staff. Now, when we talked about this in terms of how you all view it in your in-house roles, some different perspectives, Jason, you had a really good answer that I should have recorded, so I hope you remember verbatim what you said in the green room. So I'll start with you in terms of your view on maybe some lessons learned from the off-platform messaging sweep and how you're thinking about it at your organization and what you're hearing from your clients.
Yeah, well, I think the broader point I think I was making in the green room was more so just that, those are really useful cases to drive changes in behavior in-house. Like when you really want your team to listen to you, you can point to those types of actions and say, look, it's not just me saying it as the boring, annoying compliance guy who's telling you what to do all the time. This has real effects. This is real money that's here. And so I think I will miss that if that kind of goes away, the ability to use some of these, I don't know, call it broken windows cases, but some of those types of cases to really use to drive behavior changes that we want to see. I think specifically with the off-platform messages, I don't think that concern, at least from inside the registrants, is going away. We see, at least from my perspective, from my seat as a research vendor, we see that concern a lot in the compliance on the compliance teams at hedge funds, PE, investment firms, where their people are communicating, because this is really a huge people problem that we have. Is like there's so many new communication channels opening up all the time, and the business, it's always important to keep in mind as legal compliance professionals that the business is probably operating at 10x the speed that you're even thinking about it operating, and so you really need to struggle to keep up with what they're doing. You need people, you need boots on the ground who are working with those operational folks to understand how they're communicating with clients, with experts, with other firms, whoever they're communicating with, just so you can stay on top of what they're using. Are they using WhatsApp? Are they using Signal? How are you going to put controls around that to make sure that they are or they are not? You know, is your BYO device policy, is that really helping you kind of keep that all ring fenced? I think those are kind of things that pop up from those cases in terms of lessons learned.
And Shamoil and Dave, I'll turn to you two next, because I think with your organizations, you have some differing views on it. Shamoil, obviously, the books and records requirements apply. They can be cumbersome. There's no carve-outs. And then Dave, you're not at an SEC registrant, but have obligations as a public company, and obviously compliance with your own policies and procedures for preserving documents. So why don't I start, Shamoil, with you and your thoughts on this topic?
Yeah, it's a hard one because the rule isn't really designed to capture the way in which we communicate nowadays. If you think about when the rule was drafted, what it was designed to capture, it was designed to capture really letter-type correspondence or memoranda-type correspondence. It wasn't designed for the way in which we talk about things now. If you think about your average text message, it's not necessarily a substitute for email. In fact, we typically use email then for more formal communications. A text message is more like a verbal conversation, and when you exclude verbal conversation, it makes it all the more strange to say that you can have a conversation in a hallway, but if two people are side by side and they text each other, that is somehow going to be more important. And so, because the rules themselves are problematic, there's an opportunity here to have a conversation about whether those rules should be adjusted in light of all of the sweep activity that happened. There's no question that there are record-keeping requirements. You have to follow the record-keeping requirements, but in this instance, they don't make a lot of sense, and they don't really work to anyone's utility and benefit. I think where I see the issue, I agree with the fact that on the regulatory side, we won't see something like this in this administration, but it is a roadmap for the civil litigation point, where we will see requests for this kind of communication recurring kind of across the board in any kind of litigation that we have, simply because people know that it exists, they know it's out there, and it costs nothing to ask the question. And that part of it makes it a little more complicated, because from a company standpoint, you want to have a common sense sort of rule. You want to say, look, if you text somebody and say, I'm running late for the meeting, that's not something we need to retain. But that's not within the rules themselves, right? That's not what 1784 says. And that's something that plaintiffs' lawyers are likely going to want to request. So it's a real conundrum for how you address this.
And it's a little bit easier being the non-SEC sort of registered entity, but in the public company space, where yes, we need to be thoughtful about preserving communications, but we don't have the same very strict rules that apply to registered SEC entities that require a more extensive communication retention. So we have taken full advantage of the sweep to drive culture change, as Jason talked about. I think we've been pretty successful in that. People understand that there are lots of reasons we need to retain these communications, and we'll keep after it. But we also have been very careful to carve out exceptions that might not fly in an SEC registered business, but which we think are important to recognize are the practical needs of the businesses that we run.
Would your exceptions work? Because it always strikes me that when you carve out an exception, the very next text is going to be opposite the exception.
So the kinds of exceptions that we talk about, I think are things that are pretty basic, like communications about timing of meeting. I'm running late for lunch. Can you call me? We are clear that substantive communications need to be on official channels. And we also have done a lot to put company phones with archiving tools in the hands of people who are regularly texting. And so I think by reducing the need and also creating what I think most people in both the business and in the legal and compliance team recognize as practical, reasonable exceptions to the rule, we've had pretty wide acceptance. I think you can absolutely come up with hypotheticals where you end up with something that somebody thinks is an exception, and boy, we wish we had captured that. But I think that's going to be a pretty small subset of communications, and we're comfortable living with that risk.
So Carrie, I think the thoughts you have on this, to go back to where Jason started, was a little jarring at first when you're sitting in your chair, but there's opportunities for dialogue with whether it's senior management or board members about improving processes around communications. And what were some of the things you took away from that experience?
Yeah, we do have some registered entities, so, the 17A3 and A4 requirements of those entities, you feel like they've got good systems, controls, processes in place, but I think, like everybody, there's an opportunity when there's huge settlements to use that as an opportunity to change culture and behaviors, to have sort of a scalable solution. And then, as a public company, we really look at the DOJ's guidance for the effectiveness of compliance programs, and there's guidance for public companies in there. So it may not be a very specific, 17A3, A4 books and records issue, but we're regulated by states. They have books and records requirements. We're a public company. We follow the DOJ's guidance for the effectiveness of compliance programs. And so we took that as an opportunity to have a good scalable solution for the company.
That's great. Thanks, Carrie. So I want to pivot to another topic, and that's working with outside counsel. This is an enforcement conference. Many folks in here work in that space. I think most of the time organizations, when they get a subpoena by the Division of Enforcement, at some point will engage with outside counsel. Some may pursue defending it on their own if they're large enough, like Schwab. But what I wanted to ask, and I put this out there with the caveat that we don't need to talk about internal investigations with any level of specificity, but generally, when is it that something comes up either through maybe your whistleblower program or maybe through your compliance program where it rises to the level that you start to think, we really need someone independent to come in from the outside, work with us, do an internal investigation, and report in some appropriate way, whether it's to a subcommittee of the board or whatever the right structure is. And so I want to just kind of get your thoughts. I'll start with you, Dave. I know you've been on both sides of this, and get your thoughts on how you think through that, and not just when, but how you approach making that transition point from we need to move forward in that direction.
So it's really a risk-based decision, and there's a whole matrix of factors that I think everybody here would be pretty familiar with in terms of what's the potential magnitude of the issue, involvement of senior people, systemic issue, potential for enforcement action. There's probably a good handful of additional things, but there is a point where having the credibility and independence of an outsider is important, and part of the job of an in-house team is to help the organization recognize.
Shamoil, you obviously are at Schwab, with a large group of in-house lawyers, many with SEC experience like yourself. How about for your organization, how do you all work through that decision-making process for when to look to go outside for that help?
Yeah, we typically think of it in terms of heightened reputational litigation or regulatory risk. In those instances, we'll typically partner with outside counsel. And then even separate from those factors, if we believe that there needs to be at least the perception of independence, and I say perception of independence, not because an investigation wouldn't be conducted independently, but because sometimes the fact that an outside party is looking at that gives more credibility to that investigation, we'll do something like that as well.
Yeah. And Carrie, I know you obviously have a large team as well that can handle some of this type of work in-house. What are your thoughts on this topic?
A lot like Dave, where there's a good matrixed process for deciding what factors may trigger the need to go outside, but it's important to have that plan ahead of time. I think having a good investigations policy, knowing what those factors are, is super helpful, because you don't want to be making that decision in real time. You want to know what your triggers may be for going outside. I think that having investigations or issues that may involve Section 16 officers, executive officers of the company as a public company are, some really important factors to consider in whether you go outside. That would probably be a trigger to go outside, but also knowing, sort of what, if it's a board-related issue that triggers, notifying the board or having the board lead the investigation, having those plans in place and know sort of whether it's audit committee oversight, whether this is something that may require a special committee of the board, knowing all those factors ahead of time is super critical to making good, fast, real-time decisions.
That's great. Thank you all. So let's just move forward through the internal investigation process. You get towards the end. Remedial efforts have been implemented, and the prospect of self-reporting comes up. Again, generally, not specific to any of your firms. I know what my advice was 95% of the time or 99.9% of the time under the prior regime, and that was there's no value proposition for you, with all due respect to the staff in the room or former staff. You were going to get charged, and you were going to get a penalty, and you were going to get greeted with all the optical and reputational risks that went along with it. There's messaging from Chair Atkins that may no longer be the case. I think there's some hesitancy to fully embrace that, but here we are under his regime. Judge Ryan is the new director. You're moving through the internal investigation. What are your thoughts when you're getting to that very important decision with outside counsel and working through the prospects of self-reporting? And Shamoil, maybe I'll start with you.
Sure. I think I think the point is well taken. The receptiveness of administration to a self-report and to being treated like you affronted an issue is really important. And if an entity, an agency, an office suggests that they're open to those conversations, then I think that's a worthwhile consideration. I'm also thinking about, practically speaking, whether or not there's going to be a whistleblower, for example, or somebody else, or the conduct that we are looking at that would necessitate a self-report is somehow going to become known to the public anyway. That has to factor into the calculation as well. But certainly the receptiveness of an agency is significant.
Dave or Carrie, how about your thoughts on the prospects of working through that self-reporting decision?
So I agree completely with what Shamoil said. The only thing I'd add is that I would love not to be the first organization to sort of see how this new administration's attitude toward this is going to work. Track record counts for a lot.
Yeah, I totally agree, and I think it will be helpful. What will help in-house counsel start to influence their decisions is to see the practical impacts of it. When cooperation kind of memos and guidance came out, a while ago, it was good to see publicized cases or publicized matters where, staff could kind of articulate the benefits of self-reporting or how it actually, helped the reporters. And I think that'll be an important piece for, registrants and registered entities to consider.
That's great. So for our last couple minutes, I'm going to pivot again to another topic and talk about artificial intelligence. I'll go back to you, Jason. And I want to talk about this topic both in terms of how you engage with outside counsel, but you had some really good thoughts on utilization of artificial intelligence. Not that in-house lawyers or in-house compliance people are going to lose their jobs, but that those advancements in technology will allow better resource allocation, improved efficiencies, et cetera. So I'll start with you on how in an in-house role you can embrace AI.
Yeah, I thought that conversation was interesting. It was spurred by Shamoil asked me, like basically, who's your next hire? What's the next lawyer look like that you're going to hire? And I thought I couldn't think of one, and it was because I wouldn't hire another lawyer. I think because of AI, I've got a decent number of lawyers on staff now that I can invest in, technology to kind of build them up. But I think the advantage of that is being able to deploy those lawyer resources I would have used. It reminds me, like Mark Cuban had a quote when Gen AI was really starting to get a lot of press earlier on. He was saying the companies that, I think it was Mark Cuban, the companies that are just looking at this as a way to cut headcount are the ones that are going to be left behind. The ones who are going to really kind of rise up in the age of AI are the ones who are going to take those resources and redeploy them elsewhere to a higher and better purpose. And so that's kind of how I think about it. I can use these technologies I don't need to hire another lawyer to tell me, about this particular practice area. I can put those towards like frontline compliance people that, like, for the price of one lawyer, maybe get 5 or 6 frontline compliance people who I can have on the front lines where the risks really are showing up and really help me, on the battlefield at the front end of where that risk is coming in. So that's how I've been looking at using AI tools, at least from a resource perspective.
And Jason didn't want to bury the lead. He didn't offer me a job.
Hey, Dave, real quick, and this is the last question so we can wrap up. What are your thoughts on expectations for your outside firms and how they're using AI?
We expect them to be using it in a lot of the same ways that we're using it, and to be efficient. I mean, law firms are a tremendous repository, often of really deep knowledge. Are you taking the steps to make that knowledge accessible to all of your practitioners to help us solve our problems? For me, that's kind of a top line issue.
Great. Well, I think we're out of time, so thank you, everyone, and thanks as always, Bruce.
Thank you, Jim. Great job. Thank you so much to the panel. That was a really great way to do the keynote.